Hello, everybody. It's Dave Neal, stand-up comic and host of Bachelor Nation News, and we have a Clayton Echard paternity scandal update. His accuser, known as Petitioner, a.k.a. Janeth Doeth, desperate to dodge deposition, files motion to quash deposition, and you're going to see the emails between her lawyer and Clayton's lawyer and some of that legal jarring that goes down. It's mixed martial arts in the legal setting. Absolutely fascinating stuff. Follow me on Instagram at DNeals, patreon.com/Dave Neal for behind-the-scenes bonus content. I'll be live right after this on Patreon to continue to discuss this further, and also Bachelor Rush Hour, the hit podcast, every afternoon. Let's dive right into it. On December 29th, there was an expedited motion to quash deposition of Petitioner. Again, Petitioner is Janeth Doeth. We're going to get into that court filing right now, as we have now been made aware of these court documents. So in the matter of Petitioner versus Clayton Echard, it's an expedited motion to quash deposition of Petitioner. And here's what they say. Petitioner, Janeth Doeth, files this motion to quash the deposition noticed by respondent for January 17th, 2024. And by the way, a deposition is a sort of like you're swearing under oath to answer questions from the opposition. So it's a chance to poke holes at someone's story and get things on the record if they're going to perjure themselves or things like that. Both parties agree that Janeth Doeth is not pregnant and they do not share any minor children. Despite this agreement that there is no paternity for this court to establish, respondent will not stipulate to dismissal and instead noticed petitioner's deposition. On December 28th, undersigned counsel emailed petitioner's counsel and asked if petitioner was willing to postpone the deposition until we have a ruling on the dismissal. Email exchange between counsel at 4, so we're going to share that. Respondent's counsel responded with a revised notice of deposition. There are no hearing dates upcoming. Petitioner concedes she is not pregnant with respondent's children. There's nothing left for this court to adjudicate. And people say, well, it's the fact that she fraudulently lied about these babies. And she says now, as we saw in the last video where she commented yesterday to the Sun article, I did in fact have a positive pregnancy test. It's like, first of all, no one cares about your stupid positive pregnancy test. Everyone cares about her saying she was pregnant up until weeks ago, having a visible baby bump in a court hearing where she did not know it would be live streamed to the public. So did you only want that baby bump for the judge to see and not for the internet to ponder? Either way, plenty more email exchanges to show. Court does, and so again, this is also from Jane Doe's lawyer. Court does not rule in favor of petitioner's request for dismissal. There is no reason petitioner's deposition must be taken immediately and cannot wait until after this court rules on the motion to dismiss. This request is expedited because the deposition is currently scheduled for approximately 2 weeks from now. Oh, what's that? 2 weeks from now? Cue the 2-week countdown. Oh boy, we would love to see that deposition, wouldn't we, folks? I mean, don't we just want to see the truth out there? Wherefore, petitioner respectfully requests this court quash respondent's deposition of petitioner, currently scheduled for January 17th, 2024. Oh gosh, I'm going to be on the road that day. I tell you what, I'll make sure to pull over and do some breaking news stories if this deposition happens, and any other deposition of petitioner until after the dismissal is ruled upon. So essentially what Lexi Lindvall here is saying, and again, this was before she dropped her client. We got news yesterday that Lexi Lindvall dropped her client, Jane Doe, but she was able to file these motions beforehand. Some more information. So I think we just got that. Yeah, so we already got that. So yeah, it looks like January 17th is the date. Let's go to some of the emails between Lexi Lindvall and Isabel. Lexi and Isabel. Doesn't this sound like two sorority sisters get accepted to different colleges for grad school, become lawyers at opposing firms? Now they're, just like, will they ever become friends again? All right, here are the emails. Lexi, this is from Clayton's side, from Isabel. Lexi, of course, just let me know when you are available. I will place it on our calendar for the 17th at 1 p.m., pending your client's confirmation. So that's Isabel of Clayton's side saying, all right, sure, we'll put it on the books January 17th. Oh, our schedule's wide open. Let's go for that. And then we'll have her response next here. she responds to Isabel. Isabel, sorry, I have another hearing. Oh boy, I'm busy that day. The whole month is pretty crazy. She says, I have a hearing at 9:45 a.m. on the 17th. If you could wait for my availability and my client's availability. Oh, everyone check Jane Doe's availability. Are you busy today, Janie? Old Janie Doe, are you busy? Yeah, can you spare some free time to tell the whole truth, nothing but the truth, so help me God. She said, I'm busy. Check for the availability before drafting notices. That would probably save you further unnecessary attorney's fees. So this is Lexi Linval's way of saying, let me save you guys some money right now and just hold off. I already reached out to her regarding 117 at 1 p.m. and I'm waiting for her response. I understand professional courtesy requires us to agree on a date, even though I will be filing my motion tomorrow. Isabel says to Lexi, no problem regarding the deposition on the 12th. So it looks like they initially wanted it on the 12th, as we'll, of course, work with your schedule. I'm attaching another notice of January 17th at 9 a.m. Please note this will be in person as our office pursuant to Rule 57. So that is Clayton's side wanting in-person reads, you know what I mean, in person, a deposition here. And then Isabel's response to Lexi, no problem regarding the deposition on the 12th. We already got that part. All right, so they look forward to seeing her and Jane Doe on the 17th at the office. How exciting would that be? Let's continue. Lexi says to Isabel, by now you have probably seen the motions that we filed earlier today. Is your client willing to postpone the deposition until we have a ruling on the dismissal? If not, I will be... I'm sorry. This is from petitioner Jane Doe's side. This is from Lexi. By now, you have probably seen the motions that we filed earlier today. Is your client willing to postpone the deposition until we have a ruling on the dismissal? If not, I will be filing an expedited motion to quash the deposition sometime tomorrow, which we saw. Even if it is not quashed, I am not available on January 12th at 9 a.m. I have a hearing in a dependency matter scheduled for 10:45 a.m. I'm assuming you plan to depose my client for a while. Yeah, we're going to need to clear the schedule. Make sure you have some Cliff Bars ready to eat, get a nice venti coffee. Put a diaper on, get ready, because we're going to be sitting there for a while. Jane Doe is not willing to commit perjury by signing the affidavit you sent over. The affidavit that Clayton's lawyer sent over read something like my client, wanting her to say she was never pregnant with Clayton's children. That's what they wanted her to say. They said, we'll dismiss this if we can all agree we're not in some loony town where you actually thought you were pregnant. We know you weren't. Let's just agree on that. And she says, no, my client will not commit perjury, which apparently is a first for me. The court will not be able to order her to sign it. She concedes she is not pregnant. There cannot be a finding of non-paternity for a non-existent child. Clayton's only viable claim at this point is for attorney's fees. If he insists on proceeding with the deposition when a motion to dismiss is pending, he's racking up needless fees. Okay, very, very nice that Jane Doe's moral compass doesn't want anybody to rack up any needless fees. Now, they have no problem racking up needless fees when they're on the offensive. Oh, but now that they might depose my client, let's all save a buck. Come on, let's save a buck. Let's do 2 for Tuesdays at Applebee's. I got a senior discount card we can use. My AAA card will get me a free Coors Light. Let's all save some money. I tell you what, if you want to save some money, let's dismiss the case you have against me. Why don't we do that? That case isn't viable. About as viable as the twins she claimed she had. Please let me know whether you will agree to postpone the deposition as soon as possible. If I don't hear from you or if you don't agree, I will proceed with filing the motion to quash. And of course, they've proceeded to file the motion to quash because they disagree. It's a legal standstill moment here. So here we have the other filing, petitioner Janeth Doe. Petitioner's notice requiring strict compliance with Arizona rules of evidence. Oh, please. Come on, we gotta play by the rules now. Petitioner Janie, pursuant to Rule 2A, Arizona Rules of Family Law Procedure, hereby notices this court that she requests strict compliance with the Arizona Rules of Evidence and all evidentiary proceedings herein. So that's I guess the last motion her lawyer filed before canning her, and I guess we have what's left of this email here. That's just the attachment there. It says this was initially sent to your client weeks ago. This is from Clayton's side. So she is well aware of her Rule 49 disclosure obligations, as well as her duty to produce the documents requested. If you need me to send along a blank HIPAA release for your client to sign, I am happy to do so. One was included in our December 12th email to her. So it almost looks like while Jane Doe claims that she signed away all of her HIPAA releases, everyone could see it. She claims all that, but given the chance to actually sign the HIPAA release, it feels like we are hearing the unnatural sound of crickets. Just like those same crickets we hear when we asked Chase J. Jones if they would be willing to get on a Zoom call because they wanted to maybe verify that they were not involved in this court case. Crickets from Chase J. Jones? Also crickets from Janeth Doeth? What are the odds? All right, and in other news, if you haven't checked out, file this on the bingo card for different lawyers that have run away from this case. Quick, run for the hills, Lexi. You can be saved. You can still join our Patreon, patreon.com/Dave Neal. So either way, I wanted to share what a stranger wrote. Someone I don't know, just an honest opinion I thought was interesting, claims to be a lawyer. Says the emails between Clayton's attorney and Jane Doe's attorney. Clayton's attorney is trying to schedule a deposition of Jane Doe, presumably to ask questions about her pregnancy and poke holes in her story while getting her testimony under oath and in a written record. Janie's attorney is begging Clayton's attorney to wait until the judge rules on the motion to dismiss before scheduling the deposition. So if it gets dismissed, case goes away, and then Jane Doe doesn't have to get questioned under oath. Looks like Clayton's attorneys aren't agreeing to postpone, so they are scheduling a date. Janie's attorney filed an expedited request to the judge to rule on the dismissal before the deposition. Basically, Jane's attorney is hoping it gets dismissed before the deposition so that Jane Doe doesn't have to lie her way out of a paper bag. Then the person says, I'm a lawyer, but not a family lawyer. If another lawyer asks me to postpone a deposition, as long as they have a good reason to do so and we are making decent progress, I almost always agree. But here, it doesn't make sense to agree to postpone because the whole point is to have an opportunity to question Janeth under oath and catch her in some lie. Otherwise, Clayton's attorneys would be giving up the only opportunity to confront her before a possible dismissal. I really hope the judge does not dismiss this case. They also said it's kind of icky that Jane's attorney keeps making comments about Clayton's attorney's fees. As far as I can tell, his attorneys are doing their job really well and aren't filing a bunch of superfluous motions, etc. They are being reasonable asking to schedule a deposition, which they are entitled to do under the rules of evidence. It's not Jane's attorney's place to scrutinize this. She's basically accusing them of wasting time to make money. I don't blame her for quitting this case. What a mess. What a mess indeed. Let me know what you guys think. I mean, are there more documents out there from the recent motion? Maybe. I tried to get you everything that we saw. Of course, it's kind of hard for a non-legal expert to try to explain it all. But I hope you guys understand. Leave a comment if I got any of this wrong. I'm bound to do that. Wild stuff. Looks like there's a lot for us to wait on from this judge. One, will she dismiss the case? And two, if she doesn't dismiss the case, will she quash the deposition? If I'm this judge, while I don't want the court system to be wasted, maybe, just maybe, the other cases that she's dealing with are kind of boring. And she's like, you know what? I got some of that extra Christmas popcorn left over. Let me eat it before it goes stale and watch this long deposition. I wonder, it's got to be very tough for a judge because on one hand, they're human. They're supposed to do their job, but they're human and they might go, this is getting very interesting. On the other hand, if they are a stickler for the law, they might say, well, no baby, no court case. In which case, I think the only thing Clayton could do is go back to the civil case where she has a restraining order against him and maybe try to reopen that and say, hey, can we appeal this based on this new evidence, blah, blah, blah. I'm not sure what will happen here, but my guess is if this case gets dismissed, it's going to piss off a lot of people who just want to hear the truth. Let me know what you think. We'll be live on Patreon right after this.